Well now, the Supreme Court, bless their hearts, they're fixin' to mull over a pair of cases come Tuesday. These cases, they're all about them social media accounts of them public officials, and they got that First Amendment stuff all tangled up in AM. It's got folks wonderin' how them politicians oughta be chattin' with their constituents who ain't too pleased and they're postin' them critical comments. These here cases, they're a fresh chance for them justices to figure out if them public officials, like them school board folks from California and that city manager from Michigan, can put the kibosh on them critics from their social media hangouts. Seems like everyone's usin' them social media platforms these days to talk government business with the folks. The High Court didn't want to tangle with that 2021 case where they said President Trump couldn't shut up his critics on Twitter no more. That matter got moot after Trump lost his job and Twitter kicked him to the curb. So, these cases for Tuesday, they got them same kinda legal questions floatin' around, and they're part of a whole mess of legal tangles the justices gotta sort through this year. It's all about how folks talk on them social media spaces, don't you know? That Jamil Jaffer fella from Columbia University's Knight First Amendment Institute says, the court, they wanna have a say in this here debate. Each of these cases, they're important in their own right, but when you put them all together, they're gonna have a big ol' impact on how we talk in that digital public square. They're figuring out how much power them government folks got when it comes to speakin' and regulatin' in this place where folks yak about politics. Last year, them justices kinda sidestepped a big decision about Google, Twitter, and Facebook and whether they should be liable for what folks say on their platforms. But this year, they're fixin' to figure out how that First Amendment fits into this newfangled digital world in a bunch more cases. So, what's got the folks riled up on Tuesday is this question of whether them public officials are wearin' their government hats when they're fussin' with their social media accounts and blockin' folks from seein' or talkin' about what they're postin'. If they're playin' a government, then that First Amendment says they can't hush up them critics or squash them disagreeable opinions. But if they're just regular folks, well, then they got more leeway. The big question is how you tell the difference. The Biden folks, they're standin' with them government types in these cases, sayin' that blockin' folks from their private accounts is a-okay, 'cause they ain't actin' official when they're chattin' online. That Solicitor General lady, Elizabeth B. Prelogar, she's warning them justices not to go making broad rulings that'll turn private talkin' spaces into official business. She says it'll just make them government folks scared to say a word, and that won't help free speech none. Now, the American Civil Liberties Union, they're sittin' with them citizens who got shut out from them digital places for speakin' their minds. They're tellin' the court not to let them public officials kick folks out just 'cause they're givin' him a hard time. In the first case, there's a couple from Southern California, Christopher and Kimberly Garnier, and they're mighty upset 'cause them school board folks blocked them on Facebook. They got kids in them public schools, and they keep postin' these here critical messages. The appeals court out west, that Ninth Circuit, they said them school board folks, Michelle O'Connor Ratcliffe and Tia J. Zane, well, they sure look like they're doing government work on their pages, so they can't be blockin' folks left and right. They're talkin' about school meetings, surveys, budgets, and such. Seems like a government thing to do, they say. But that lawyer for them board members, he says you can't go messin' with their First Amendment rights and what they say on their private accounts. He says them Garniers, well, they was leavin' the same comment all over the place, so it's more like spam than speech. He's sayin', if the court goes this way, it'll just make folks who wear government hats too scared to talk. Now, in the second case, it's a different story. This time, a different appeals court, the Sixth Circuit, they're sayin' that a public official's social media stuff only counts as government business when they're doing their official job, or if they're using the government stuff to run their account. That city manager fella in Michigan, James Freed, he got himself sued 'cause he shut up a fella named Kevin Lindka who was jawin' about the city's virus policies. The appeals court there, they said it's different 'cause Freed's page was more about family stuff than government business. Now, when the Supreme Court dealt with Trump's Twitter account last year, old Justice Clarence Thomas, he said they gotta reckon with them big tech companies. He's worried about them private folks who run them platforms cuttin' folks off, more than these government types blockin' some chatter. Well, that's the long and short of it, folks. Them cases, they're O'Connor Ratcliffe v. Garnier and Lindka vs. Freed. So, the Supreme Court, they're gonna be chattin' about all this soon enough.